Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to talk about a state. We get to talk about them frequently. Not the most frequent state we discuss here, but they are on the short list. We're talking about the state of New York. Now, the state of New York is absolutely hell-bent on disarming its citizens. It is a state that despises the exercise of the Second Amendment. And in the short time that we've had this channel has already passed the Concealed Carry Improvement Act, one of the most nefarious pieces of gun control legislation we've ever seen. Well, not to be outdone by themselves, they have now passed a new law, and it is a very dangerous law. In America, what you need to understand is that depending on what state you're in, this kind of crazy law could be on your doorstep soon as well. So today, let's spend a few minutes and let's talk about the state that can now disarm you over a phone call. Okay, America, this is a law that was recently enacted in New York. I want you all to pay attention to it because if you think that your red flag laws right now are currently a problem, just wait until they get to disarm you outside the confines of your state's red flag laws. What am I talking about? I'm talking about New York Assembly Bill 544. Introduced on January 8th of 2025, but it already passed the Assembly, it already passed the Senate, it went to Governor Hochul's desk for signature. She signed it October 16th with an emergency effective date, which means it went into effect when? That's right, October 16th. Now, this bill amends New York Criminal Procedure Law 140.10, a law that used to look like this, but now this bill has added a bunch of additional language. There's really only one section down here, a whole new section, Section 3, that we're going to have to really focus on because I'm telling you, New York, this is going to be a big problem for you. In America, if these laws come to your state, it's going to be a big problem for you as well. Now, New York uses the terminology family offense. We oftentimes use the term domestic violence. Essentially, this is a certain type of crime that is committed by one family member against another family member or domestic partner or household member. For a person who's being investigated and arrested and accused of a family offense, pre-existing New York law already allowed a police officer who responds to a report of a family offense, one, may take temporary custody of any firearm that is in plain sight or is discovered pursuant to a consensual or other lawful search. Two, shall take temporary custody of any firearm that is in the possession of any person arrested for the commission of such family offense or suspected in its commission. And this is the new section right here, New York, and this is what I want you to be aware of, because listen to this. Shall take temporary custody of any firearm that is in plain sight or is discovered pursuant to a consensual or other lawful search when the officer has a reasonable belief that it is necessary to remove such weapon to protect the victim or other persons present or to prevent risk of further violence or threat. Okay, and so here's what I want you to understand, New York and everyone else. If we go ahead and we take a look at what was previously permitted under New York law, which is that an officer is making an arrest or conducting a lawful search, those are both supported by what? That's right, probable cause, right here on our levels of proof. However, what Section 3 now provides is that an officer can merely do it based upon reasonable suspicion. And it's not even reasonable suspicion of criminal activity. No, instead, it's reasonable suspicion of that it is necessary to remove such weapons to protect the victim or other persons present or to prevent risk of further violence or threat. Now, if any of those activities already constituted probable cause, the officer could make the arrest. So what this law does is that an officer who comes out and makes an investigation for a family offense, a domestic violence offense, which, by the way, law enforcement officers around the country take these offenses very, very seriously. And many times statutes mandate arrests, mandatory custody, mandatory court first appearances, things such as that. I'm sure New York is no different than any other state. But this now permits them, in the absence of probable cause, translation, in the absence of the lawful authority to arrest anybody, to just say, well, in my judgment, I'm going to take the firearms anyways. And here's the thing. Unlike red flag laws, where theoretically there is some type of a judicial hearing where evidence is theoretically weighed and there is at least a record made of it, or in a protection order hearing or restraining order hearing where again there is some semblance, not much, of procedural due process. This is a decision that is now allowed by an officer, not a judicial officer last time I checked, to make this decision in the field supported by something far less than probable cause. Oh, then in Section 3C, another huge amendment, only a few words, but it changes everything because under pre-existing New York law, if a firearm had been taken and a court order was not obtained within 48 hours, the firearms needed to be returned. Now, the government has up to 120 hours to obtain some type of judicial order to keep those firearms. So you have more than double the amount of time for the state of New York to go out and get some type of a judicial order that would then permanently prohibit possession of these firearms. And let us remember that that order would also be supported by what? That's right, a reasonable suspicion, the same standard the officer got to use in the field, rather than a finding of probable cause. Which means that every New York resident right now lives in a state where if there is a call and police come to the house on any type of family offense or domestic violence call, even if no arrests are made, even if no probable cause is formulated, even if no reasonable suspicion of criminal activity is even discovered, so long as the officer has some kind of a reasonable belief that maybe disarmament right now would be in the best interest of everyone, they get to do so. And at the current time, New York, there is nothing that you can do about it. Okay, New York, it's Assembly Bill 544, signed by your governor October 16th, effective immediately. We'll go ahead and link it all up down below so that you don't have to take our word for it. You can geek out on it for yourself. Now listen, if you got any questions about this, or anything else related to what's left of our Second Amendment rights, which in New York is not much. You guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing, click on that link, tell us all about it. If you want to subscribe to the monthly newsletter, that link is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.